a member of DLHub, and this evening we are glad that we are having this webinar, and we hope and desire that every one of us is going to go home with something out of it. And it's my hope that you came with something in mind that you wanted achieved for you, some questions that you have that you want to be answered. We have received some of your questions that our facilitator is going to go through them, but we encourage us to continue to give the questions. But before the questions, what is your anticipation? We encourage every one of us to tell us, what do I hope to get out of this meeting today? This is good for all of us, and it's also good for you because right from the word go, you will be knowing what you are looking for. And it might go build your expectation, which is also what we are expecting, that this webinar is going to give us information enough that will be build what we had expected. And so welcome all of you. As I've said, I am a member of DLHub. I'm representing the members in this webinar as a moderator. So without wasting our time, much more time, I wish to introduce our speaker tonight. Our speaker is already here, and he's a person who has come in with a wealth of experience in ADR, AJS, and he's going to give us the difference. And we would also request him to tell us what really motivated him to get so much on this line. So I wish to introduce our speaker tonight. Our speaker is David Njuguna Njoroge. David is a senior partner and a visionary leader at the head of dispute resolution at Njuguna Njoguna Company, advocate. This is a boutique law firm based in Embu. He is an adjunct lecturer at the University of Embu law firm. He's a board director and an approved tutor of the Chartered Institute of Arbitrators. And he's also pre-qualified ADR tutor at Nairobi Center for International Arbitration, NSC-ADR. David is serving this nation in different dimensions. And David is serving the judiciary as a member of National Environment Tribunal. And he's also a member of National Steering Committee for the implementation of the Alternative Justice System policy. He has served as a member of the State Corporation Appeal Tribunal, that is 2019 to 2022. The National Steering Committee for the Formulation of the Alternative Dispute Resolution, NSC-ADR, that is 2020 to 2021. And he's serving as the chairman of Embu County Accredited Mediators. David has a special interest in ADR, AJS, generally, and its growth and development in the country as the most ideal mechanism of dispute resolution and social transformation in the society. And so we are in safe hands when we are with David, and he's going to bring out a number of these things. So join me in welcoming our facilitator, David Njuguna Njoroge, with some flowers. Can we welcome our speaker with some flowers, please?
Thank you. Good evening. Confirm you can hear me, Beth?
Yes, I can hear you.
Thank you very much. Thank you for the warm welcome. And thank you, members, for the flowers and the celebratory reactions that I can see still streaming. First, I would like to appreciate the brains behind the DR Hub, my good friend, Assunta. This journey started a few years back, and I was in the ropes with it in terms of consultations and just advice. And I am happy that it has actually grown to this level. And Assunta and the entire DR Hub were very well done. I'm truly proud of you. And that is why I assured you that at whichever time I'm needed, I will be there for you. Thank you, Beth, for the elaborate introduction. I hope that we will enjoy the session. Allow me to begin where I should, and that is the dichotomy between ADR, AJS. And before I go to that, you have asked me the motivation that I had in immersing myself into matters ADR, matters AJS. Long time ago, as a young lawyer, I was debating on which LL.M I should pursue, and sorry for that. As kindly let's mute. I was debating on what I should pursue, and I had an interest in intellectual property, and I tried to join a distance learning, UNISA, and the support was not there. And then I stumbled upon one of my even today mentors, Professor Kariuki Muigwa, who introduced me into this space, and I started the journey. And it has been a rigorous one, taking me to fellowship level and also my LL.M in international arbitration. But it has been a fulfilling one. That one I can say. It has been quite fulfilling, especially when it came to COVID, when courts were closed. We all know that lawyers, many of us suffered a lot, but the alternative dispute resolvers, there was a hike in terms of the need and demand for our service. So that is why I keep on encouraging the young lawyers, the upcoming ADR practitioners to diversify, be an expert in dispute resolution. That is what I am today. When a client comes, I will open up all the doors, an array of the multi-door system, and ensure that the most appropriate, the most efficient, the most fast and quick, I will deliver it to you, and you will pay me my legal fees. There has also been the question of bread and butter. I will demystify it to my learned colleagues that it is not a threat to our bread and butter. If anything, it is an addition of peanut butter to our bread. So allow me to share so that we can start the presentation. And first is the question of ADR, AJS. What is ADR? What is the dichotomy between AJS and ADR? And I want to submit from the onset that there is a difference, and when you look at it again, there may not be a difference. What am I saying? The Constitution talks about alternative dispute resolution. When you talk about alternative dispute resolution, we are talking about the different models in ADR, and that is right from negotiation, mediation, conciliation, arbitration, adjudication, expert determination, and all. Those are different models. But in terms of AJS, AJS is alternative justice systems. Those ones were models. Alternative justice systems are systems on their own. They are magnanimous, they are big enough, and they basically cover. It is an umbrella to everything that is settled out of court. So we need to be very, whether it is through traditional, I will also dissuade us from thinking that AJS is the traditional dispute mechanisms that we knew before Yawaze and all that. AJS, I am an AJS practitioner, really. I am an elder in my own way. So we have elders even in the youth, as long as you can be able to take the agency that the Constitution talks about and be able to deliver justice and administer justice, then you are an ADR practitioner. So on to today's topic, the legal framework and practice. I want to draw this to what I always talk about, going back to our roots. And why I've titled it Going Back to Our Roots, it's about time that we need to reevaluate ourselves and see, is the formal justice system as is today, is it serving to its optimum? The problems of backlog of cases, the problems of accessibility to formal justice, the problem of affordability. If you want to go to court, you may need to hire a lawyer. The expenses involved, the time involved, cost-benefit analysis. I want to submit that it's about time. Remember, before the colonial era came, we used to resolve our disputes in our own indigenous ways. We used to do that without differentiating that this is criminal, this is civil. I know it's a big debate. I'll also talk about it. But our elders and our systems then used to resolve disputes across board without any discrimination. So I submit to you, it's about time that we need to reevaluate that, of course, in line with our very transformative constitution. So we will be looking, this is just a frame of what we will be looking at today. And in the conceptual background, why AJS? What are the foundations? The statistics never lie. We need to look at what are the statistics in court so that they can inform us whether actually it is working or not. The transformative constitution, I will demystify how transformative this constitution is. It is one of the greatest piece of constitution in the world. The legal and policy framework for the lawyers, if you're looking for the grounding, the legal, the policy, I will give it to you, and also the case law. The typologies, what are the different types? Agency, what is that agency? As lawyers, we know without jurisdiction, there's nothing. I will give you the jurisdiction, advantages of AJS. Then we'll see it in action and how it needs to be promoted. Then importantly, we look at the role of ADR practitioner. As an ADR practitioner, whether a lawyer or not, I have put this in one basket. A lawyer, a mediator, any ADR practitioner, what is your role in terms of AJS? Can you play a role? Can you join the gospel and spread the word? I submit to you that indeed you can ably do that. Going to the conceptual background, and here we are looking at where did all this begin and how do we handle it? And the first issue is that disputes are inherent in aspects of the society. Whenever we have a society, as day follows night, then you can be sure that there will be conflicts and disputes within us. Question is, how do we handle them? Formal legal systems, the backlog of cases cannot be re-emphasized, and where it has led us to. The gap in the resolution. In court, when we go to court, do we really resolve a dispute? I want to submit to you today, in court, we get determination based on the evidence and the facts that have been adduced by the different parties. The judge, the judicial officer gives a determination. That is the reason one party will be happy, the other will be aggrieved, will come back to us as the lawyers, and we, of course, take up the appeal and make more money. But have we resolved the dispute? The dispute is not yet resolved until you go to the highest court, Supreme Court, and otherwise. AJS underutilization, we'll see how, if we utilize AJS, all this can be resolved to finality. Exploring alternatives before going to court. Again, research has told us that the US, 95% of cases, because of the multi-dose system, 95% of cases, civil cases especially, are determined or resolved outside the court. Accessible, affordable justice. It is accessible. When you talk about AJS, it is your next door person. It is a person that you live with in your communities each day, each and every day of your life. AJS is not big. When there is that mzee kumi, nyumba kumi, and the mzees who are able to resolve disputes, that is AJS. When the boda have their outfit and they have a disciplinary process that resolves disputes within them, that is AJS. In the church setup, when you take up your disputes to your church leader and faith-based and they resolve them, that is AJS. So we dissuade the notion that AJS is only the traditional aspect. It is not. So it is accessible, it is affordable. And then the grand norm of the transformative constitution that we have. What are the foundations of AJS? Where did we come from? Why should we try AJS? African customary law, it is indigenous. It is solid in our African customary law. If I would ask the lawyers and the law students and the legal trainees in the house, do you have any unit that in your curricula that basically talks about and teaches the African customary law? There isn't. And that was very intentional. Why? Because when the colonial rule came, they came with the English legal system, which is foreign, which was strange to us. And I would urge you to look at Lord Denning when he said that you cannot expect an English eagle to be supplanted from England, dropped in Africa, and expect it to behave the same way and character that it had. And that is why the problems are there, because it has not been customized, it has not been integrated, and now we are here, we are. There are diverse indigenous systems. When AJS talks about systems, the different communities that we have, they have their own organic way of resolving disputes. The ineffectiveness of the courts, post-colonial era, and now the need to look at these shortcomings. Multi-sectoral resolution. AJS has been used. AJS has been used to settle even issues of cattle rustling, multi-sectoral things that even the formal system cannot be able to settle. But AJS, due to its diversity in terms of and its informality, it has been able to resolve wide-scale disputes. People-centric, I'll talk about the transformative nature of the Constitution and how people-centric it is. This is a constitution by the people, for the people, to the people. So the question is, and we love asking is, whose justice is it in AJS? Whose justice are we seeking? Is it for the lawyer who is prosecuting the matter? Is it for the DPP? Is it for the DPP prosecuting? Is it for the defense lawyer? Is it for the civil plaintiff defendant? Is it for the court to restate the letter and spirit of the law as it is? We have seen Muratetu has come and disturbed the status quo of the letter and spirit of the law. So that spirit lives on, that we need not follow the spirit, but there are other ways that we can find justice. I want to submit to you, justice is in the eyes of the beholder. Justice for the parties. If the parties so craft what they perceive to be justice, then so be it. Professor Mark Galanter talked about this quote that really captures this. Just as health is not found primarily in hospitals or knowledge in schools, so justice is not primarily to be found in official justice dispensing institutions. That is our courts. Ultimately, access to justice is not just a matter of bringing cases to a font of official justice, but of enhancing the justice quality. What is the quality of our justice that we are seeking? Of the relations and transactions in which people are engaged. People, people, people. Let me share the statistics of what our formal justice system is about. That is the court, with all due respect. Of course, they do a wonderful job, but it is too much for them. This is the SOJA report, the State of Judiciary report. I like this bit between 2019 to 2022 because we have an interlude of COVID, and it also spans out and comes out very clearly in terms of the statistics. As you can see in 2018, 2019, one thing, Kenyans, we are a litigious society. We love filing cases. And with the lawyers, it's our bread and butter anyway. So you can see cases filed 435. Cases that were resolved in that year. Of course, these 22,000 are cases that were filed, maybe have been pending for 10 years, 6 years, and so. What were they? The unresolved cases in that year were 95%. You can see it has always been ranging in 90s. 2019, 2020, 2021, just look at it, it goes down largely because of COVID. When COVID happened, the next Tuesday, I remember very, very well, the CJ Emeritus Maraga stood on the stairs of the Supreme Court and shut down the courts. And our lives as lawyers came to a halt. What just happened? We get our bread and butter largely from litigation. When we have dates, when we have mentions, when the case is moving, but now it has been closed indefinitely, you can see there was a fall even in terms of filing of cases to 298, the next year to 310, the resolution and resolved cases dropped to 85 and 82. Look at when COVID ended. We came back to 90s. We came back to 336. Today, the SOJA report of last year states it is in excess of 450 cases filed annually. So what is the constitutional basis of this AJS? Do we have a bearing in terms of law, in terms of the constitution? Yes, we do. And the first of them all is Article 1, the sovereign power. This is a ground-breaking provision and none that has been there before, and it changed the whole environment in terms of the dispensation of governance, dispensation of all human relations in this country. Previously, you know the previous constitution. Beth, kindly mute the persons interfering. Yes, in the previous dispensations, constitutional, you'll find that Section 1 was talking about where did sovereignty reign. In the independence, pre-independence period, it reigned in Her Majesty, the King or the Queen, as at then. After the Constitution, after the independence, it just shifted from Her Majesty to His Excellency, the President. That is why we had presidents who are very, very powerful, so to speak. Jomo Kenyatta, President Moi, because sovereignty reigned in the presidency. So Article 1 is very, very critical because it changed the whole dichotomy of constitutional order in this country. AJS has also been incorporated by law. We will look at it. The Civil Procedure Act will look at the various acts that are provided for this. Importantly, we now have the policy, the AJS policy 2020. And this came after my chair in the National Steering Committee on implementation of AJS, the good Professor Justice Joel Ngugi, and the committee, the task force then went around the country 2016 to 2020, came up with a beautiful piece of policy that I would really urge us to get a hold of. This is the AJS policy, a simple document, but very, very elaborate, and changes the scenario of justice conversations in this country. And it was launched on Katiba Day, on the 27th August 2020. And now we are the committee that is implementing the same across the country. So we have all the legal framework, policy framework in place. We just need to implement, and we have been doing that. I will also be covering that. And then lastly, what is the mandate of the judiciary? In Article 159, it is a sole mandate and it is not a request. It is an obligatory mandate by the Constitution. The people of Kenya stated that the judiciary should promote AJS. In their promotion, they should protect it and they should transform it. Let's talk about the transformative constitutionalism, and I must admit I borrowed a lot of this research material from my chair, the good Justice Joel Ngugi. It talks about two critical modalities that were very fundamental, changing the constitutionalism in this country. The first one is the civic autonomy. Vide Article 1, sovereignty to the people. It brought back all the power to the people. We only donate it to the various organs, that is the legislative, the executive, and the judiciary. So they exercise it on our behalf. The second most important, especially to this topic, is access to justice. Article 48. And it basically presupposes that access to justice at every instance, the people of the country, the various state organs should ensure accessibility to justice. So civic autonomy, it reconstitutes the citizen, it asserts the voice of the people, and that is why we saw the people's power, even the Gen Zs coming out, because they have the power under the Constitution, and it asserts the agency. We look at the agency because it is very, very important. Agency is all about jurisdiction. So looking at access to justice, which is our concern, it is expected that Article 48, as an enabler and facilitator of all other rights, that in whatever state organs are doing and state officers, you should always enable and facilitate access to justice. And we have seen a stream of legislation streaming from the Constitution that is in enabling and facilitating other rights to be enjoyed as provided by the Bill of Rights. Secondly, as a facilitator of justice conversations and discourse, we need to change the conversations of justice in this country. Why? Because we have to ensure that there is access to justice. Gone are the days that justice only belonged to the powerful, the rich and the famous. Justice is a right to each and every person, whether low, whether high, all are entitled to it. The Archbishop Desmond Tutu reminds us of this. There comes a point where we need to stop just pulling people out of the river. We need to go upstream and find out why they are falling in. It has come to that we need to pause a bit, take a breath, go upstream and find out what is the cause from out there before we come and rescue these ones, because they will keep on coming down. So what are the parts of access to justice? The first one, it is an emancipatory jurisprudential discourse. See Article 22, 23, 24. And this was at a time when there was over-reliance of technical justice in the pre-2010 judiciary. Just a few cases in highlighting passing. You remember the case of Dr. Gibson Kamau Kuria versus AG. This was at the height of the Moi regime. And it was at a time that he wanted to exit the country in exile. And he did not have a passport, went to get a passport, and he was denied. He moved to court under the old constitution to enforce his right to get that. And the court then said that he did not have, this is a personal right and it is not enforceable. So it was thrown out on that technicality. The cases, the election petitions of Kenneth Matiba and Mwai Kibaki 92-97 versus Daniel Moi. We all know that those election petitions were thrown out at the preliminary stage because the then president, Daniel Arap Moi, was not served in person. And lastly, the case of Wangari Maathai versus Kenya Times, we remember the question of locus standi, who are you? Why do you want to stop the building of Kenya Times at Uhuru Park? And the case was dismissed. But we have moved now out of this because of Article 22, Article 23, which states any person, whether directly or otherwise representing, that is why we have the rise of Okia Omtatas of this country. They're doing a wonderful job protecting the rights of others who may not be able to go to court. The second one is as a modality of justice conversations and processing grievances. This is where it falls now squarely on AJS. So in place of traditional rule of law, reforms try to come up with laws that provide for these things. The Constitution focuses on access to justice. And as long as you maintain and ensure that is respected, then you will have achieved this. The statistics from the Justice Needs Survey, which was done in 2017. And these are the statistics that came out, and they should worry you as an ADR practitioner. That out of the cases that are there, the aggrieved parties, kila mtu ako na kero ndani yake. 19% of them in the country, they do nothing. That is very serious. That they have a grievance, but they have lost hope. Either they cannot afford, they do not trust, they have no confidence in the systems, but they live with their grievance. Ni wale wanasema, sawa tu, Mungu amekuona, tunaiachia hapo. 19%, very disturbing statistic. Then next is 17%. 17% goes to court. And to break this down further, 17% out of the 17%, we have only 4%, 3% of the 17% who willingly go to court. So you, the lawyers, you, the dispute resolute, especially the lawyers, we only get 3%. Those that come to my office, I advise them and we go to court. It's only 3%. 14% of these 17 are those that are taken unwillingly. They have been sued. They are being prosecuted, whether criminal or civil, but they have gone to court unwillingly for a whole 14%. So it's only 3% lawyers. That is our bread and butter, food for thought. Next is 64%, a whole 64% goes to alternatives. They resolve their disputes outside court. What does that mean? Either they go talk it out in negotiation, either they find a mediator out there from AJS or from wherever, they find a conciliator, they go to arbitration, adjudication, expert determination, and all the others, or simply they just, in an alternative manner, resolve their dispute. This is where I always challenge my colleagues. Where do you want to be? Do you want to be in the 3% that we squeezed a whole 22,000 of us? Or do you want also to have a bite of this big cake of 64%? And I submit to you that I am in both ends, and the law and the Lord have been good to me. So I welcome you to this other side. So that is the statistics of the disputes in this country. So what is the legal framework? Constitution of Kenya, I've talked about Article 1, Article 2, the international bringing it home, Article 3, 10. 10 is very critical. Public participation, which has been elevated a lot in this country as one of the common basic principles. Public participation, the people-centric issues, they must be always participated by their owners. Article 27 on discrimination, 48 access to justice, 63, and the grand norm of it all is Article 159, which now basically grounds issues to do with alternative. Then we have the High Court supervisory role under Article 165 and also 159.3. People always ask, is there a stop? Is there a check in AJS? Yes, there is. Article 159.3 clearly says that all these things must abide by the principles of the Constitution and they cannot go beyond what they're supposed to do. So the supervisory role of the court is there. So the court will still ensure that in all this AJS that is going on around the country, that it is going on as per the Constitution. The civil procedure, the court annexed mediation, section 59 has incorporated this. It is also a form of AJS. The AJS policy in itself that I will also be talking about shortly after this. The international instruments, Article 33 of the UN Charter. I actually do not know why today I have a problem with I come from the school of thought led by Professor Kariuki, who says ADR should be appropriate dispute resolution because it is appropriate for you to try before you go to the ultimate. Article 33 of the UN Charter, 1948. Then they knew what is the chain of rising to the court. And it states whenever there are disputes, they should be resolved first by negotiation, mediation, conciliation, arbitration, adjudication, and last result, court intervention. How we intertwined that and overturned it upside down to now consider these alternatives as alternatives and first going to court, and then the court now is sending us out there, is still a big debate out there. So specifically Article 159 2C. It is in mandatory terms that alternative dispute resolution, including reconciliation, mediation, arbitration, dispute, traditional dispute resolution, shall be promoted by the judiciary. So it is not a request. And that is why you have seen the CJ has been very vocal in terms of opening up the multi-door system, in terms of preaching the gospel of AJS. You will note that every other time she's launching a court today, the former courts are given to AJS, so that we are calling them Ukumbi suits, where AJS panels and their resolutions are done there, and it is working magically. 2023, this is what she had to say. The judiciary, once viewed as a sole forum for access to justice, now champions the understanding that justice should not be contained within its rigid parameters of the courtrooms. We understand that justice, like water, needs to flow freely and uninhibited, permeating the cracks and crevices of our societies, that it should penetrate in all the parts of this country, flowing freely, touching every life it encounters. The judiciary cannot do that. How accessible are our courts? In our rounds of AJS, we've gone to the northern part of the country, and we find that a court is over 200 kilometers from Mwananchi. Is that accessible? Has that water of river of justice drained to the doorsteps? That is what justice ought to do. It must drain to my doorstep, whether I am in Kajiado, whether I am in Northeastern, whether I'm in Hola, whether I'm in Nairobi or wherever, it must come to my doorstep. So what is AJS? This is a new phenomena, and our good chair has been exporting this jurisprudence and knowledge, and it's being called left, right, and center across the world to talk about this. And now African countries are following us. Uganda, for those who attended the summit, the mediation summit last week, we had testimonies from Uganda who learned this from us, and they're doing marvelous work. They've fully integrated it even into criminal justice, and it is working miracles. So he has defined this. I suspect he's the only one in the world who has defined this, the scholar that he is. And he says AJS are a comprehensive organic. These words are very critical. Organic. Organic is something that is out there on its own. Hakuna GMO inaongezwa. It is just doing its work on its non-state mechanisms. No state is involved. Norms, customs, social and legal systems. Systems, we talked about systems, not models. Because when you go to Coast, there's a different system of Mijikenda. When you come to Marland, there's a different system of Maasai. When you come to Central, there's a different system of the Kikuyu community, which govern and regulate the entire spectrum of activities and lives of individuals from birth to death. That this spectrum is right from the time you are born to the time that you die. These norms, these customs, systems are there with you. We cannot wish them away. They are constituted, applied, and enforced by the people themselves. The people, remember, Article 1, the people, in their own communities. They include dispute resolution mechanisms, which we call AJS mechanisms, which does not usually involve using state courts. Must pause and digest that for you to understand what AJS is all about. It's a beautiful, beautiful exposition. So what are the types? This framework, this policy framework that was came up with, when they went around the country, each and every part of this country, they came up with 4 models. And I will be talking about 3 because the 4th one, we do not encourage it because it is more regulated and we do not want to regulate things that are organically out there. The first one is called autonomous AJS mechanism. Autonomous, as the name suggests, it is something that is autonomous on its own, organically, in the community, without anyone's influence, interference, help, or otherwise. That the people of, for example, my neighbors in Meru and in Cheke, they just sit there, listen to disputes, make and resolve them, without any third party coming to tell them, do this, do that. That is the biggest percentage of the mechanisms that is out there. And of course, this is out of our customary indigenous community-based, depending on the community you come from, they had been, our forefathers were practicing this. The second one is called the third-party AJS mechanism. Third-party AJS is whereby, yes, it is indigenous out there, it is doing its work, but there is a third party that has come to help them in one way or another. There's one aspect which is state-based. So state-based are the Ngao system, the chiefs. We all know that the chiefs and the Ngao system assists a lot in terms of dispute resolutions in the interior parts especially. So that is the non-state third party. Then we have the non-state, that is the state. We have the non-state. Non-state are NGOs. When you talk about ICJ has been working a lot in terms of capacity building of paralegals across the country. I've been involved in that as a member, capacity building them and helping them to penetrate to communities to help them resolve. Kituo cha Sheria has also been very strong in the coastal region. They have been assisting us a lot. Kelin, very strong in terms of matrimonial disputes and succession disputes in the Nyanza region. FIDA Kenya, very many organizations, LRF, and very many others that are helping in terms of just coming and assisting communities to resolve their disputes on their own. Then the third one is the court-annexed AJS mechanism. And just as the court-annexed mediation, you'll find that there are cases that are already in court. And here is where we have the doctrine of interaction. The doctrine of interaction with AJS is whereby AJS is interacting with with the formal court system. Either there's a matter in court, it's a boundary dispute, really. You take a matter of boundary dispute, you expect the ELC judge to make a determination and determine this is the dispute. Really, just give you a determination, you'll not be happy, you'll appeal. So it is better, it is referred to an AJS mechanism. For example, in Kajiado, working very well. The Kajiado County government has helped a lot the AJS committee in terms of implementing because they are facilitating them. So they have put together a panel which includes a surveyor, includes an adjudicator, includes a land registrar. So once they are referred, they just go to the ground, they sort out the issue, then the matter, the report is filed back in court, and the court adopts it as a final court order. Working wonderfully. Sorted out. Today, you never hear of the many land disputes in Kajiado, which were problematic a few years before. It is largely because of the AJS intervention. Also, there was this, or the panels, the AJS panels, when they are determining this matter and listening to them, it may come to a point whereby, for example, there is a title, but they find that the land does not belong to the holder of the title, and now they do not have the power to cancel. So through the doctrine of interaction, court annexes, they refer it to court, and the court now does what is necessary legally. So it is the interplay between the AJS and the court from either party reference, the referral mechanism. The fourth one is the regulated AJS. I said that we do not encourage this, and why do we don't? Is we do not want to regulate. The beauty of AJS is its informality. It's in no issues, kuja tu ulivyo. So no rules, no nini, but all play within the framework of the Constitution. So the next question that comes in line is agency. We all know as lawyers, jurisdiction is everything. Lillian's case, if you do not have jurisdiction, must down your tools. This question, I have seen it has been asked, which are the cases that can go appropriate for AJS, which are not? This is the only test that we do. The agency theory test is all about a positive test and a negative test. The first question you have to ask yourself and the parties is, are the parties before you voluntarily on their own free will? So it must be voluntary by the parties. They have agreed to come and submit themselves to AJS. If the answer is to the positive, mguu moja iko ndani ya AJS. The second question is a negative test. Is there a legal barrier that stops you from entertaining such a matter, whether by law, policy, or public policy? For example, issues to do with minors in this country under 18. Touch anything to do with minors, they do not have consent. So that is a no-go zone, it must go to court. So issues to do with the defilement, issues to do with questions with the minors, that is a legal issue and must be reserved for the court. In our trainings, we capacity build them and we train them that these are the red flags. You cannot go to this. When something has some legal technicality, for example, it's a violation of a constitutional right, you will not really help them by listening to them because you will not issue any declaratory, compensatory, or so those are matters for the court. If a title needs to be cancelled, you cannot entertain it. It has to go to ELC court, which has the jurisdiction. If it's an issue to do with the divorce, unless you are really reconciling the parties, but you cannot issue the decree absolute and decree nisi. it goes to court. So there are those very clear lines. When it comes to legal issues, the legal issues go to court. But I assure you, the majority of the issues in our disputes out there are not really the legal issues. It is just issues of their interests, positions, and as long as they are aligned within the AJS system, then it is in order. So, ladies and gentlemen, that is the test. As you have seen, there is no issue of whether it is a serious criminal case, whether it is a complex civil matter. These are just the tests. As long as you answer these tests, positive and negative, you have an AJS panel that is ready and willing to delve into it. So be it. We will see it in action shortly. So what are the advantages of AJS? Due to its informality, due to its nature of accessibility, we have restorative and reparative. Questions have been, for example, in criminal, you have an assault case, you want the person to go to court and then be punished, and then what? Is there any restorative, reparative justice? Holistic dispute and conflict resolution. It doesn't look at just to make a determination. It looks at holistically the conflict and resolves it. There's a beauty in resolving matters out of court. Just to give an example, and this was in mediation. Mediation is also awesome. I was given a matter, in a criminal matter, an assault matter here in Embu. And when we went to resolve it, and I keep on telling people, you'll never have your day in court that you will come and give your story. The court has precious time to not listen to you. There are statements that are already written that will be adopted. You'll just be grilled by the opposing counsel. So you'll never have your day in court. But in mediation, I will sit down and listen to you all day. And you'll tell me all the things that you want to tell me, and I'll be very patient. Kuwa mediator lazima ukuwe na nyota ya patience. So when I was resolving this dispute, assault, it ballooned, and the real issues were that it came out clearly that there was a pending succession matter in court, and there's also a pending ELC matter in court. And I assure you, hadn't we arrested it at that point, the next thing would have been a murder case, because it's always a circular thing that goes round. When I resolved, and the beauty of this alternative is that you can expand your jurisdiction and resolve. Just the world is out there for you to just bring everything into fold and resolve the dispute. When I did that, we resolved not only the assault case, but the pending succession matter and the pending ELC. That's the beauty. The court would not do that. Those are different cases. We'll take different turns of events. We'll take a lot of time combined together over 20 years, but alternatives offer this. Streamlined access to justice. Anybody, it is accessible that next door, you will just get this justice within your community. Reduction of case backlog. It has helped a lot. At the summit again last week, the CJ shared the statistics, and he shared that that the success rate of mediation in this country is, I think, 94%, which has unlocked 69 billion in the last financial year. So you can see how powerful it is. You're helping the court, the cases to move out. You are locking back into the economy, and all is well. Voluntary nature of AJS. Very voluntary. It is the first test. If any party does not agree, then stick to court. Informal and highly, hakuna mambo ya documents, plain documents, civil procedure, compliance and all that. Kuja ulivyo, tuambie na ile lugha unaelewa. Inclusive justice, where all participate. The women, if there is anything that we preach in AJS, it is the inclusivity. and the dictates of the Constitution in terms of inclusivity. The women, the disabled, the vulnerable, the youth. When you hear of AJS panels, it is not, I told you, it is not really the elders that we know. These are people that you relate with. There is a youth sitting there. There is a disabled sitting there. There is women sitting there. It was celebration in the second AJS conference when we went to Samburu the first time, because we normally go to a place and observe how they are doing, and then we train and capacity build them on the human rights approach and the dictates of the Constitution. We found that in Samburu back then, when women, even when they had their grievances, they could not access the panel, the sitting panel. 100 meters, they use 100 meters, you give it to a man to take it and present your grievance to the panel. Then they finish, eat their nyama there, and unakuja unaletewa the outcome. So you can imagine how far we have come. But in the second AJS conference that we had last year, we now have a Samburu Council of Elder Chair in a lady. That is how powerful, that is how transformative our Constitution is, and that is how people are receptive. In Jurincheke here, we now have ladies sitting in as panels. It was never had before, and that is now what we're doing. We are very proud of the progress that we are making. So inclusivity is very, very key. And then people-centered justice. We will sit down, tailor-make a resolution that you can never get anywhere else. As I come to wind, just to rush a bit, AJS in action. Cases, the case of Mohammed Ado, 2013. There's a bit of criticisms back then. You can see it is 2013 when the judge adopted an alternative that was settled out there. This is where Mohammed murdered somebody and then came to plea. Before the case started, they went into the Masla system, and he was taken through, admitted to it. 100 camels exchanged hands to the family of the victim. Mohammed was taken through a rigorous process of reintegration back into the society, and he became actually a champion of anti-violence. And he was fully reintegrated into the society. They were good friends with the victim's family, and they lived happily thereafter. Of course, he was coming for his mentions, but the witnesses were nowhere to be seen until 2-3 years down the line. The judge sent probation to find out what happened. When the report came, the judge endorsed it. There was a bit of criticism that is endorsing some murder. It's a serious case, and now why should it be endorsed? But look at what are the optics, especially to the family. They've been reparated, 100 camels. Life cannot come back, but at least they have something. Look at the perpetrator. He's been taken through a reformative process. And if he were to go the formal legal process, maybe after 8 years being sentenced to 40 years in prison, he would still go to prison and never come back to this community because he's excommunicated. So there's a break of family and an entire generation of relation with that community. So really, whose justice is it? Isn't it for the parties, if that is what they have seen to be fit for them, working for them, reparating them, reforming such persons? If they're gone to prison, it still be having that grudge even after 40 years. He will now have no place to come back home. The family, the victim will never get over this because after 8 years trial, sentenced, case imeisha. That's it. The second case is Kitur versus Kitur, 2023, recent one. This is where AJS, the determination on trust land, adopted by court. This was a son We all know the traditions whereby the firstborn son used to be written in the titles. Then now he claims he wants to own it. So when the matter came to the ELC court, there was a report that there was an AJS panel long time, 1994 years before, that had made a determination to this. And actually there was minutes and recordings and all that, and found that actually it had been proved, and they found that it was trustland. The court adopted it. Respect. Promoting AJS, respecting it. They respected it, and the matter settled. Bor versus Ngisirei, 2023. Again, a herdsboy who was a herdsboy in a farm. When the owner died, he had left a portion of him. The family was declining whether he should be given or not. Again, taken to AJS, and AJS found indeed that he was actually adopted, even though the legal process was not followed. But for all intent and purposes, this was an adopted son, and he was given his 4 acres. The court again respected and endorsed that as the final settlement. So there's also the Kajiado case, a Kajiado case whereby there was a man with a title, stayed in court for 30 years, but he knew he didn't want to prosecute because, of course, it was an easy shut case, open shut case, because he has a title, just swing it and indefeasibility of title. But he knew that this land was not his, it was for another widow, but he did not want to prosecute it for this long because he knew that, and if he did that, when he went to AJS, now he confessed, he said that he knew that if it was declared so and the woman was to be evicted, he would get KASNEB and 4 of his generations, so he didn't want. So in AJS, they were able to talk it out. It was realized kumbe hata huyu mwanaume ana kero yake. A strong, powerful brother had also squeezed him out of his land. So they were all called, this is the Ma community. And it was finally resolved, and it was a big celebration. Actually, the governor of Kajiado and our chair, Justice Joel Ngugi, were called into the celebration. And it was a happy ending. Everyone got back their land despite the title ownership, and they live happily thereafter. So multicultural conflicts, cattle rustling, we have deployed a part of our team to go and in those talks of cattle rustling, and we are seeing successes in that. Now, formal justice can be able to do some of these things. So what are we called upon to do as I come to an end? Promoting AJS, judiciary's mandate, it is dictated by the Constitution. What we do is we do county action plans, because from one community to the other, there are different natures and how AJS will play out. So we do a needs survey, justice needs survey in a county. We see what is the justice issues that are coming up in a county. For example, in Kajiado, it was a question of land. In Mombasa, they have questions of issues to do with terrorism, issues to do with gang communities and all that. Nakuru, issues to do with gang. Central, it was issues to do with petty crimes and all that. So we tailor-make something and implement it as a county action plan. Ensuring adherence to human rights. It is very critical, and we never negotiate on this, that the Constitution, inclusivity, principle of non-discrimination are very paramount and the right to be heard. Natural justice principles cannot be wished away. So we capacity build these panels, and they are doing well. They are living to the same. Stakeholder collaborations, we need to collaborate a lot with the stakeholders. When we go to a community, you find if it is the church that is helping them out, like the faith-based in Nakuru, they have put up, the church in Nakuru have put up a whole floor and have opened it up as an AJS panel. The success of AJS in Nakuru cannot be gainsaid. When you look at the cost list in Nakuru today, you'll see the normal course list, and you'll see an AJS course list. So every day there is a panel that sits and listens to disputes and they resolve them. So it is quite one of the success stories that, and we have covered many counties, about now heading to 20, and the intention is to unleash it to the entire 47 counties. Integrating AJS course units. Yes, I talked about the way that we were trained as lawyers. We were trained to be very abrasive, to be always looking at a fight in court. Of course, it's a friendly fight in court, but we need to reevaluate that. We need to look at what our indigenous ways. Why didn't they teach us on our African customary law? Why did they teach us about English legal systems only? So we need to reevaluate that, and by and large, curricula and conversations around this, and even having an AJS BSc are already in the pipeline. Embracing community models. When you go to a community, we must respect what they do, because if you don't respect, they will not accept what you're telling them. So you just observe, respect what they are doing, and then you tell them on the ways to improve. Organizing workshops and all that. So what is your role? As an ADR practitioner, as a lawyer, I want to submit to you that you must be provoked by this 64% justice, and you need to be part of that. Modern ADR is a dispute resolution expert. That is what you should be. ADR adopts a holistic approach to a dispute. You must learn, relearn, and unlearn. Present a multi-door system. When a client comes, just open up the doors. Whichever works for them, the better. The pre and post 2010 Constitution, especially the lawyers, when today's lawyers look at the Constitution and you see restraint and you see limitations, it is you who has the problem. There are a lot of opportunities for us as lawyers and dispute resolvers generally. Just look out for it and run with it. We are the pillars of justice. We are the ministers of justice, and I would really urge that we live up to that. As I come to an end, this is a clarion call by the Honorable CJ for everybody to bear their own weight and take agency that we've talked about, for ensuring that we all become champions of justice. Justice belongs to all of us. Justice cuts across all our lives. We need to play our constitutional mandate to ensure that we deliver justice for the people, and the people themselves become agents of their own justice. Article 1, when everybody bears their responsibility, from individuals to institutions, we promote resolution. We actually know we need to resolve our disputes before even we go to court. As I conclude, I want to conclude on a very spiritual note. I hope it will be my last nail to convince you to join this side of the 64%. Matthew 18:15 and 16 says, instructs us, members, to settle their differences privately with each other. And if that fails, they are to seek in resolving the dispute. Just seek somebody that is a mediator or a third party, AJS. The Holy Book of Quran, 49:9-10, instructs the Muslims, brethren, if two parties among the believers fall into a quarrel, make you peace between them with justice and be fair. For Allah loves those who are fair. The believers are but a single brotherhood, so make peace with your brothers. I want to end by Martin Luther King, who said that true peace is not merely absence of tension, it is the presence of justice. Ladies and gentlemen, I urge you all to clear the path of justice. I thank you very much. Back to you.
Thank you very much. Our presenter, Njoroge. I'm sure we all have gotten something, and especially the call and the space that is available for all of us out there. If 64% of the cases are there available to be done by the people that are handling AJS, then we have some space. I'll request Diana if there are some questions that have come. Diana, it's your time. Please handle them.
Thank you. What a riveting discussion. Very informative. This should probably have been a week-long class. We have so much to learn, so much new information. Thank you, David. So we have Lewis Ndegwa in the chat, and he is asking, why is the legal field reducing in ADR arbitrators? Why is the legal field reducing in ADR arbitrators? And just to encourage everyone, please type out your question in the chat. You can also raise your hand and so that you can unmute to ask your question directly. We also have Roy Koske, who is asking, what is the standing of AJS in criminal cases? David has highlighted a few cases, but maybe you can just tell us the final standing of AJS in criminal cases. You have told us that there are red flags, there's defilement and cases that include minors, but maybe you can answer, Roy, to satisfaction, what is the standing of AJS in criminal cases? David, the floor is yours.
Okay, thank you. Thank you, Roy, for the question. What is the place of AJS in criminal, the standing? As I have told you, the only test that we have are those two tests. First, have the parties come voluntary? Is there any law policy that is stopping you? If there isn't, then it is a matter that AJS can entertain. We do not go as a committee, we do not go preaching that criminal matters go to AJS. But our experience and what we have seen in the communities day and day is that the reality is many of these matters are being resolved in the community. It is our obligation to ensure that we teach and capacity build, train these communities to ensure that as they delve into that, then they know where to stop and they know what is the constitutional expectations and they meet the constitutional minimums. If anything goes against, of course, the High Court is always there and the courts are always there to supervise and call out anyone that goes beyond their mandate. So it is happening. Again, I had just in the summit in Uganda, they have taken seriously mediation and AJS in their criminal matters, and it is resolving a lot of their disputes. The judge there, Judge Andrew, who is the director of their Judiciary Academy, was saying that it has actually helped them a lot, and it has helped to even ease the congestion in the prison. And the communities are finding it that it is working, because if there is some negotiations and there is some reparation and restorative justice is being gotten out of it. They are running with it. They are running with it seriously. In Uganda today, you can plead again, you can negotiate on anything in a criminal. As long as it is workable, then so be it. So that is the spirit of justice conversations, and whose justice is it? And indeed, it is for the party. The other question, I forget who had asked it, it's about the legal field reducing ADR. This has always been whether all these alternatives are coming to shrink the space of the legal practitioner. I have always been of the view, respectable view, that it is actually offering you an array of multi-door, an array of you to be part and parcel of it. Don't sit there, do your mediation, do your arbitration, do your adjudication, learn AJS, and be an expert in all this. So that a dispute is a dispute. I've come to realize today and appreciate that there is no complex dispute. What? Dispute is a dispute. And as long as you are well skilled in matters handling a dispute, you will handle whichever dispute that comes your way. So I'll just urge the legal practitioners, let's not see when these other professionals, of course, mediators, we have very many non-legal mediators, and they're doing extremely well. Arbitrators, we have engineers, we have QSs, we have architects. It is not ours. You cannot be selfish and say it is ours. They are experts in their own areas. So it is not shrinking the space. It is actually an opportunity for you to diversify. Thank you.
Thank you, David. So it is an addition to bread and butter. It is not a threat to their bread and butter. That is well understood. We have also a few more questions. We have Maria Karani asking, at what level can domestic violence be resolved through AJS? And we also have Eddie Muya, who thanks you for the masterclass and asks, how practical is it to run AJS without state regulation? How practical is it to run AJS without state regulation? We also have a question, the last question now. Do practitioners refer to customary law when it comes to deal with a court-annexed mediation? We have, that is Salma Benayed from Tunisia. Wow. She is asking, do practitioners refer to customary law when it comes to deal with court-annexed mediation? We are 3 minutes past the time that we borrowed, but David, you can answer those questions as we close.
Okay, thank you. And let me start with the diaspora. Thank you for tuning in all the way from Tunisia. This is good. Mediators use customary law in court-annexed mediation. In mediation, really, what really happens is not about the law, so to speak. But in mediation, we normally try to look at what are the positions, what are the interests, and what are the needs of the parties. Separating it from the legal angle, whether it is the formal legal systems, their rights, and their positions, but looking at more of their needs, interests, and aligning those positions. So I wouldn't say that customary law would play, but of course, in the discussions within within the mediation, then customary issues can come, and if at all you will need to be advised on that as a mediator, then so be it. You can call for it. The other question is, Eddie, state regulation, is it practical? I can assure you the reason why we do not encourage the regulated AJS is because it is a regulated one. It appears to be a regulated one. And regulated AJS, you know, when you regulate something, when you find people who are living in an informal manner, in a very unstructured manner, but their things are working, you bring structures, you bring regulations, guidelines, and whatever else, they will shun it. So we do not want to disturb the status quo. We have tried this, it is working, and yes, I can confirm 100% without state regulation, it is still. But is there an overarching regulation? Yes, there is. The constitution is there, the courts are there to ensure that everything is done in accordance with the law. And then to Maria's question about domestic violence, as I said, you know, in terms of AJS and alternative, they look at a long-term resolution. So perhaps if this issue goes to court, it will just vex the other party, and the other party will still, this thing will recur again and again. And if both parties are willing to submit to AJS, then they find a lasting solution, which they normally do, then it can help. But if it goes to the extreme, then it is a preserve of the formal judicial system. I think those are the questions. Thank you.
Thank you, David. And even as you tackled those questions, I believe you answered Kathleen, who asks, should it be her understanding that AJS is pegged to the culture and customs of a particular community while taking into account the Constitution of Kenya and respect to human rights? So her summary of what you have said is that AJS is pegged to culture and customs of a particular community while taking into account the Constitution of Kenya and respect to human rights. You tell us if you agree with her assessment. And Martha,
yes, I think that is a good summary, because as I've told you, when we go to the coast, we find they have their own identical way of doing things and their cultures and their norms. As long as we are teaching them on the respect of the constitutional minimums, they can do it. When you come to Meru, it is different. And again, as long as we teach them the constitutional minimums, then that is why these CAPs, the county action plans, there is no one photocopy for the other county, because it's diverse communities, diverse cultures and norms. So we have to tailor make for each community in the country.
Right. Thank you. We also have Martha, who is concerned about AJS sometimes being repugnant to justice and morality and discriminative in some instances, in as much as we do appreciate the fact that the systems are still deeply rooted in our cultures and many work in some cases. So she's giving credit, but also sharing her concern on AJS. Otherwise, we have a lot of flowers for you and your very informative presentation. And we have 2 more questions. I do not want to lock anyone out, so I will have this as the last question. We have Anne Mwendwa, who says, in developing policy around AJS, won't this juridification result in the loss of positive attributes and mechanisms like TDR and under AJS? We also have Manasseh, who comments that ADR mechanisms like arbitration and mediation call for trained persons, arbitrators and mediators. Who should, or rather who is competent to conduct AJS, keeping in mind a judge, for instance, or an advocate may not be well conversant with cultural norms of certain community. So what they're asking is, who is the practitioner in the case of AJS? I believe that should be our last question as we close the session.
Okay, let me start with the question of Manasseh. I hope it is Manasseh, I know my friend. Yes, the models, the ADR models, there's rigorous training and certifications and all that. so they are well skilled as they practice. Who are AJS practitioners? AJS practitioners are the people within the community who have been acceptable by their own people and they have been doing it. So when we go and observe, we actually observe them in action. So they already have the buy-in, that they have the confidence of the people. Like when you go to the MA community, we found that senior chiefs, former chiefs, and all that, they're highly regarded by the community, and they would mostly be the ones sitting on those panels. We have to train them on really, what are we training them? Whatever that we capacity build them is on the structures and the minimums of the constitution, but not, because they are the experts in dispute resolution and they know that community inside out, they know the cultures, they know the norms, and they effectively deliver justice to the people that they are serving. A question by Anne on policy on AJS and TDRMs. And let me make it clear, the policy did not come to basically formalize the informality of AJS. The policy is a codification of what was seen to be prevalent in the communities, so that it was able now to, the task force sat down and came up with the 3 models which are predominant within the society. So we are not making any other further formalities or making it to be complicated in any way. What we are doing is following the 3 models. Then we look at a community and we capacity build them in terms of the basic minimums, the natural justice principles, and ensure that the justice that they have been serving, they can now serve it better, and the people can be well served to satisfaction. Thank you.
All right. Thank you so much, David. This has been such a good session, and everybody seems to agree. Everyone, if you're able to, please give a reaction to David, whichever you think is whichever you think is appropriate. But thank you so much. This has been such a great session. This marks the end of our very first webinar out of the career building series. We have, as I mentioned, 4 other webinars, and the next one is on 22nd April. So if you thought you enjoyed this one, maybe you could stick around and join us on our next one, which would be Pathways into ADR, getting it right from the start. We will be having James Godo, who is an arbitrator and advocate, and Adadu, who is an independent mediator and arbitrator. We also will be having Maina Migwi, who is a mediator, a founder and trainer at Suluhu Mediation Center. So we have an array of individuals who bring a wealth of knowledge to the table for the different pathways that you can charter in your ADR journey. So if you'd like to join us, the meeting ID is on the screen. You can screenshot this. However, we'll be sharing these posters on our platforms. So however it is you got the poster for this one, it will probably get to you as well. But feel free to screenshot this. You can call us as well if you would like any more information on that webinar. Beth, the floor is yours. Give us your comments.
Thank you so much. We just want to agree with everyone that we have had a very good training, and we have gathered a lot of information from our speaker. And so we sincerely want to thank him for being so well prepared and covering so much within a very short time. I also wish to thank everyone that attended the meeting. If you are not there, this webinar would not have been there. So feel appreciated. that you attended, and I'm sure you have gone home with something, and probably you have gotten a space where you will get yourself in it. I may want to request, I don't know whether Assunta is here to just say hi, just for 1 minute. Assunta, kindly.
Hi, Beth. Thank you. I have been taking notes as well.
Yeah. So
thank you to everyone who has attended today's session. My name is Assunta Ndami, the Assunta that our dear panelist and speaker David mentioned when we started. I serve as your team lead. And so I look forward to sitting in through these sessions, learning as you all learn. Thank you.
Thank you so much. Thank you so much. I think the meeting is over now. Thank you, everyone.
Before we leave, we have Ruth Kamau who is asking whether she can get notes. Ruth Kamau and everybody else, please know that never to worry. This session is being recorded, and the recordings will be sent to each of your emails, just for your reference. Thank you, Beth. Now you can read it, please.
Thank you so much. I wish everyone a good evening. Thank you. Have a good night.
Thank you. Good night. It was a pleasure.
Good night.
Mm.